Okay, we're going to get back now to our fourth panel, which is pushing the limits of deference. We're going to be talking about Seminole Rock and City of Arlington, and our moderator for that is Stephen Menashe, who is a partner at Kirkland & Ellis and will be joining the George Mason Law faculty this coming fall. With that, I'll turn it over to you.
Thanks very much, and welcome to the fourth and final panel. The panel is called Pushing the Limits of Deference, and it's about two deference doctrines that go arguably beyond Chevron. We heard earlier today that Seminole Rock is the doctrine that a court will defer to an agency's interpretation of its own regulations unless that interpretation is plainly erroneous or inconsistent with the regulation. That doctrine originated in a case called Seminole Rock in 1945, but then was reaffirmed in 1997 in a case called Auer v. Robbins by Justice Scalia, in which he held that even when the interpretation is given for the first time in a brief in that litigation, it gets deference from the court. And it's pushing the limits of deference because, as Justice Scalia later came to believe and to express, moral hazard problems may arise when the same entity that promulgates the regulation also gets to assign it an interpretation and disputes over its enforcement. The second doctrine that we're talking about is City of Arlington, which is as I think came up earlier today, a 2013 case in which the court held that even when a statute defines the scope or even limits the jurisdiction of an agency to act in the first place, the agency still gets Chevron deference in its interpretation of that statutory provision. And so there's a concern about the foxes guarding the henhouse, I presume. So to work through these issues, we have an impressive panel today, and I'll introduce them in the order in which they'll be speaking. First up is Allison Ho, who's a partner at Morgan Lewis and co-chair of the firm's appellate practice. In that capacity, she recently asked the Supreme Court to reconsider Seminole Rock or Auer deference. The court didn't take up that invitation, but she can make her case against it here. Next up will be Aaron Nielsen, who's a professor of law at Brigham Young University. And he wrote the paper for this panel, which I take it is available on the website, called Beyond Seminole Rock, and suggests that perhaps overturning Seminole Rock might lead to further problems in the absence of other reforms. After him, we'll hear from Jonathan Adler, who's the John Verhey Memorial Professor of Law at Case Western Reserve University. He was, before City of Arlington was decided, a proponent of the notion that agencies should not get deference with respect to their own jurisdiction, and he can let us know after the court's decision the state of play on that and other issues. And then finally, we'll hear from Michael Grieva, who's a professor of law here at George Mason University School of Law, who's going to tie everything together for us. So with that, Allison.
It's a pleasure to be here, and I'll take up the gauntlet of the last panel and try to begin with some humor, especially given my introduction in terms of being here, at least in part because of a cert denied and another case that I litigated that also was a 9-0 loss. There's a great story, and I can't vouch for its veracity, but if it isn't true, it should be, that when Chief Justice John Roberts was in private practice, yes, even the great John Roberts would lose a case every now and then. And he lost a case 9-0, and he called the client to inform the client of the bad news. The client was understandably upset and said, "What do you mean? How could we have lost 9-0?" And John Roberts is said to have responded, "Because there are only 9 justices on the Supreme Court." And I think much of what I'm going to be saying today in terms of making the case against Auer and to crush Seminole Rock is not going to be anything new, and we've heard many of the things I'll be pulling together already today, but hopefully it'll be useful just as a point of bringing together the case against Seminole Rock and against Auer for further discussion today, point and counterpoint. As several members of the Supreme Court, most recently Justice Thomas in his dissent from the denial of certiorari in the case that Stephen referenced, there's a wide gulf between deferring to agency interpretation of statutes over which Congress has presumably delegated interpretive authority and deferring to agency interpretations of regulations promulgated by the agency itself. The Seminole Rock Doctrine, at least in its current form, violates both the Constitution and the APA as designed by its framers. And I'll address each of these problems briefly and then move on to talk about, and I'll come to this from a litigator's perspective, some of the consequences of our deference and in terms of, in particularly, the loophole that, in my view, Seminole Rock and our create. First, and I think Judge Kavanaugh talked about this eloquently at lunch today, our deference is a real affront to the separation of powers inherent in our constitutional structure. As Justice Scalia wrote in his Talk America concurrence, quote, "It seems contrary to fundamental principles of separation of powers to permit the person who promulgates a law to interpret it as well." The framers took great care, and for good reason, to ensure that the separation of powers was fundamental to the structure of the Constitution and to the government it established. But while judges are to independently apply recognized tools of interpretation to determine the best meaning of a regulation, our demands that courts accord controlling weight to the agency's interpretation simply because it is the agency's interpretation. This prevents judges from exercising a power given to them by the Constitution and instead amounts to a transfer of a judge's exercise of interpretive judgment to the agency, which raises serious separation of powers concerns. Second, our deference poses not only constitutional concerns, serious constitutional concerns in my view, but it's also contrary to the administrative scheme designed by the drafters of the APA, or its framers. To begin, as we heard at the last panel, Section 706 states that it is courts that are to determine the meaning of agency actions. Our rejects this judicial function in favor of blanket deference, even to low-level bureaucrats on some issues, such as positions taken in an amicus brief, sometimes filed, as in our, at the invitation of the court, but more often these days simply filed on the agency's desire. Plenary review thus aligns more closely with the APA framers' own understanding that while the act must be interpreted and applied by the agencies it affects, the enforcement of the bill by the independent judicial interpretation and application of its terms is a function which, quote, is clearly conferred upon the courts in the final analysis. In fact, the APA framers specifically noted that agency interpretations should be subject to judicial review precisely because the APA exempts them from the safeguards of notice and comment rulemaking. The APA focused on notice and comment rulemaking as the key procedural safeguard in a world where agencies practically determine the content of a great deal of federal law. And our practically and effectively makes notice and comment optional. That is contrary to the fundamental underlying principle that there should either be more rigorous process on the front end of agency action or less deference on the back end. Thus, the choice an agency has under the APA is to engage in more process on the front end through notice and comment rulemaking and secure more deference on the back end, or to forego more process on the front end, for example, through interpretive rulemaking, and give up that deference on the back end, such as Skidmore deference instead of Chevron. The problem is that agencies do not even need Chevron deference so long as our is in place, because the same decisions that would not receive Chevron deference do receive our deference if made in the context of interpreting an agency rule instead of a statute. The agency need only offer a vague interpretation of the statute and then flesh out policy considerations and specifics in the form of interpretive rules. Thus, as it stands, agencies acquire the power to create binding norms without either procedural safeguards, so from the agency's point of view, paying now, or meaningful judicial review, paying later, thereby rendering decisions such as the Supreme Court's in Meade that interpretive guidance and various policy documents should not receive judicial deference a dead letter. As a result, the practical consequences of our, and we've already heard a lot about this today, is that it seriously undermines any incentives agencies would have to draft interpretive rules clearly. In the typical scenario, as we've heard discussed, Congress passes a broadly worded statute accompanied by an authorization for agency lawmaking. The agency then promulgates an ambiguous regulation that, although preceded by notice and comment, doesn't really grapple or deal with the tough issues. So it's kind of a downhill from Congress, who in some sense abdicates its responsibility, to the agency, notice and comment, more abdication, and then it gets down to even further granular level where the rubber really hits the road in terms of the interpretive rules that really guide and determine the behavior of the regulated community. The effects of our are significant. And I think one comment that I'd like to make on Professor Walker's comments, which I think looking at the effect of Chevron in terms of what's going on at the courts of appeals is important. I think it's also important to consider the effect of our deference on cases that are never brought. Because in a world where the regulated entity is going to be litigating against its regulator, and you're advising your client knowing that if our deference is what you're facing and the odds of success are slim. So I think there are a lot of, I think if anything, probably the numbers you're showing understate the practical significance of, certainly you were speaking in terms of Chevron, but our deference as well. No one is well served by a system that increasingly operates by drive-by regulation that bears none of the hallmarks of traditional law, including notice and due process. To be sure, there was a certain logic underlying the Supreme Court's original decision in Seminole Rock. The court held there that an agency's interpretation in a manual should be given considerable weight in determining the meaning of the regulation for which it provided interpretive guidance. But there, the interpretation was used by the administrator and was issued concurrently with the regulation itself. And that's a far cry from the practice that we see today under our of allowing agencies to regulate essentially via amicus briefs filed years after the regulations the agency is purporting to interpret. The current regime does allow for limited exceptions to our deference, such as where the agency has upset well-settled expectations in a way that threatens an entire industry, but the contours of the exceptions are themselves unclear and their application unpredictable. So the rule really is that our applies, except when it doesn't apply, which isn't very often. Far better would be the regime envisioned by the APA and certainly the framers, and respectful of separation of powers. That is, agencies can only have deference on the back end when they have afforded the public and the regulated community process on the front end. Thanks.
All right, there we go. All right, well, I thank Allison for that, for the introduction. So here we go. Here's the criticism of Seminole Rock. This is from Allison's recent cert petition that was denied, and you had Justice Thomas, and he issued some of the common criticisms of Seminole Rock, and he's just quoting past cases where they do this. And I want to focus on here at the bottom. I don't know if the laser is clear enough, but by enabling an agency to enact vague rules and then invoke Seminole Rock to do what it pleases in the later litigation, the agency, with the judicial branch as its co-sponsor, frustrates the notice and predictability purposes of rulemaking and promotes arbitrary government. So that's the criticism of Seminole Rock, and I think Allison has given us a good summary of it. Now, I'm going to I find myself briefly defending it, but we're going to see this isn't really my argument. The counter argument that you often will get by the defenders of Seminole Rock there's at least three. One, is it empirically true? Do agencies actually do this? Do they actually intentionally promulgate broad, vague language so that they can have that deference later on? Adrian Vermeulen and Cass Sunstein have an essay out where there's a footnote, and Cass Sunstein says, "I've never seen it. I was at ORIA, I saw thousands of these things, I never saw it." There's another argument which says, is this really a separation of powers problem? There's actually lots of instances where the same hands both create and then implement the law. There's an article by Jason Marisom where he goes through all sorts of different constitutional self-interpretation. So for instance, the federal courts promulgate the rules of procedure, and then they decide what the rules of procedure mean. And then there's also, hey, didn't Congress implicitly adopt this scheme? Seminole Rock is in 1945. The APA is in a few years later. Hey, they knew about it, thus they implicitly adopted it. I saw Ron Levin made this argument a few weeks ago in the House. My argument has nothing to do with any of these arguments. My argument is a new argument. My argument is, even if everything Allison has said is correct, and everything Justice Thomas has said is correct about the problems of Seminole Rock, getting rid of it may actually make things worse and not better. And the reason is that even a vague rule provides more notice than no rule at all. And in a world without Seminole Rock, agencies may increasingly shift away from providing rules to instead the case-by-case adjudication of the type that John Harrison talked about earlier this morning. So here we go. My article is coming out in the Georgetown Law Journal, Thinking Beyond Seminole Rock. And it starts off with a quote from Professor John Manning. John Manning is one of the founders of this Seminole Rock skepticism. And in his article, he makes a point, which I kind of take as my launching pad, is that there's another doctrine. The doctrine is called Chenery 2. And Chenery 2 says that an agency can promulgate a regulation to solve a problem, or if it would rather, it can simply enforce the organic statute or the statute it administers directly through a retroactive adjudication. So in Chenery 2, the SEC said, you know what, we're not going to promulgate a rule to prohibit a particular type of stock arrangement. Instead, we're just going to say that violates the statute directly and you can't do it. And it goes to the Supreme Court, and the Supreme Court says, that's fine. You have the agency, you have a choice. You can either promulgate a rule or you can just enforce the statute directly. So my thesis is that if the court were to get rid of Seminole Rock, then agencies increasingly would not promulgate rules, but instead would simply enforce the organic statute directly if they're really interested in flexibility for themselves. If they want to preserve that same flexibility that you hear in the anti-Seminole Rock criticism, well, what they can do is, all right, if we don't have the opportunity to promulgate a vague rule, is we will just take a vague statute, which is already vague, and enforce it directly. And my point is, by definition, a vague rule will provide at least as much, if not more, notice than a vague statute, because a rule narrows the statute and can't expand it, or it's ultra vires. Modern Chenery 2 doctrine, it's common, it's everywhere, and it's stated here at NLRB v. Bell Aerospace. Agency has discretion, almost unfettered discretion, to choose to act by rulemaking or to act by adjudication. If it wants to act by adjudication to make policy, it can. And though we'll talk a little bit about retroactivity, so long as it's not a massive change from what came before, the agency can create policy in an adjudication that then applies retroactively. So the way I think about it is this, to kind of illustrate my microeconomics point of substitution between the doctrines. You are an agency and you have to make a decision. We want to make a policy. Do we want to make it by rulemaking or do we want to make it by adjudication? And this is very simplified, but you'll think through, well, what are the pros of rulemaking and what are the pros of adjudication? Rulemakings, you can generic resolution, which means it can be a very broad rule that's you don't have to do case by case. You can just do one rule, one fell swoop. You can get information from comments. Maybe Congress wants it. Adjudication can be a pain. You have to set up a whole ALJ process. And finally, if you value flexibility, well, then you say, all right, I'm not losing that much because if our rule is vague, well, you know what? We're going to get deference in the back end, so I'm not that worried about it. On the other hand, an agency can say, well, you know what? We're going to do this by adjudication, which it can be small, it can be very case specific, or if you want, it can be a big policy too. There's adjudications that are very broad policies. It can be retroactive, which a rulemaking generally can't be. You don't go through OIRA for adjudications. Rulemaking is a pain too. I mean, you hear the stories about ossification. And it can also be flexible through Chenery 2. You've got both of these. Well, what happens if they get rid of Seminole Rock? Well, now you're the agency and you have the same exact options, but if you value flexibility, rulemaking is now less attractive than it was before. Well, what's going to happen? Economics suggests that you will substitute, or at least sometimes you'll substitute. Sometimes you will substitute in favor of clear rules because you say, you know what, I don't get flexibility anymore, but all the other values of rulemaking make it worthwhile to do a regulation. But sometimes if you really value flexibility, what you'll say is, you know what, before I did it by a rule, now I'm going to do it by an adjudication, which means I'm not going to promulgate a rule at all. I'll just wait to bring an enforcement action. From the perspective, there's an important empirical question here, which is how often will agencies do this? Now again, you know, in my past life I was an antitrust lawyer, and we'd want to know about cross-elasticities, which is what is your preference relative to the other? Nobody knows the empirical answer to this, but the question should be, if you got rid of Seminole Rock, would the result be more clear rules, or would it be more no rules at all? And I suspect if we don't have a good answer to that question, we might end up in a much worse situation than we are now, and that's because Chenery 2, again, by definition, provides less notice than a vague regulation. If the regulation says the exact same thing as the statute, well, under Gonzales v. Oregon, you can't do that. That's the anti-parroting, so that doesn't work. So what that means is almost always a regulation is narrowing the scope of the statute. I guess it's theoretically possible that it's equally broad as the statute, but nonetheless doesn't parrot it and isn't mush. But that's pretty hard to imagine. What that means is most of the time a regulation is narrowing the scope of the statute. So in a world without Seminole Rock, if agencies increasingly shift to case-by-case adjudication, the result will be for regulated parties that they will have even less notice of the law that applies to them than they do now. And then we'll get into the world of guidance documents and agency threats and all of that, which are all backstopped by Chenery 2. Chenery 2 is the backstop, the anchor for a lot of this. So what happens next? It seems to me that until we know the answer of what agencies will do, we ought to be very wary about getting rid of Seminole Rock. Because if in fact we end up in a world where agencies don't promulgate rules and just use adjudication and guidance documents and threats, talk about cases that aren't brought, we might end up with a lot less notice and regulated parties being worse off than they are. Of course, it's possible that on net we'll get more clear rules, but there's a microeconomics question here, and we don't have the data yet to know what will happen. First rule of stare decisis should be do no harm. Alternatively, what we could do, and this is where my paper ends, is we can make adjudication less attractive, so there's less substitution. You could keep the Chenery 2 principle, which is a sound one, that sometimes it doesn't make sense to promulgate a rule because the statute is already pretty clear. So what you could do is, my thought is, if we got rid of Chevron for adjudications, keep Chevron for rulemaking, get rid of it for adjudications, then agencies, if they want to experiment through a case-by-case adjudication, they still could, but they couldn't make broad changes in the law. Instead, they could have Skidmore. If they have a good persuasive reading of the statute, they can do it in adjudication. If they have a broad reading of the statute that requires a massive change, you would cut that off. That would diminish substitution away from Seminole Rock, with rulemaking with Seminole Rock to adjudication. You could also up retroactivity, which would do the same thing. So conclusion, Chenery 2 allows agencies to do many of the same things as Seminole Rock, which means adjudication can do many of the same things as rulemaking with deference. Overruling Seminole Rock would encourage agencies that place a high value on flexibility to substitute to Chenery 2, which would result in even less notice for regulated parties. Because we do not know the answer to the key empirical question, that cuts in favor of stare decisis. On the other hand, if the court wants to get rid of Seminole Rock, it also needs to think about Chenery 2, because these doctrines are not silos. It's interconnected. There's a big web of doctrines, and if you start messing with one thing, you need to be able to account for where it's going to change on the back end. And that's the paper.
Alrighty, well, it's a pleasure to be here, to be back at my old stomping grounds to talk a little bit about these cases. I planned to devote most of my time originally to bathrooms and swamps, but Naomi told me I should talk about City of Arlington, so I'm going to say a little bit about that and hopefully still get a little bit into bathrooms and swamps if I have time. So City of Arlington versus FCC is this case from 2013, an important case, a case that I think is a bit of an outlier, certainly hope it's a bit of an outlier in terms of how we apply Chevron and how we conceive of what some have called Chevron's domain. At one level, it was a silly dispute between the FCC and a local government over the siting of cell towers and the procedures that local governments have to go through when deciding whether to allow cell towers to be sited. What the court accepted the case on, even though it was a bad vehicle for this, was on a much more important question, a question that the court had spoken about on but never decided in the past, and that lower courts were split on, which is whether Chevron deference should apply to statutory provisions that define or limit the scope of an agency's jurisdiction. The idea or the concern being that it's one thing to say to an agency, you have deference about certain discretionary choices or certain policy choices within the range of authority that Congress has given you. But on the question of what authority Congress has given you in the first place, that is a question that courts should decide, not merely because of the Administrative Procedure Act, but because it would be incongruous and perhaps even unconstitutional if Congress could literally give agencies a blank check. That is, write an ambiguous statute that an agency in the course of interpreting gets to define precisely what power Congress gave to it in the first place. This was a debate that had occurred on the court before. Justice Scalia and Justice Brennan had debated this question in a case called Mississippi Power and Light in a pair of dueling concurrences. And in Arlington, Justice Scalia finally got his victory in concluding that Chevron applies in the context of an agency's jurisdiction just as much as it does in any other instance. As I said, I think Arlington is an outlier. It in many respects represented Justice Scalia's lone victory in a recent Chevron case determining when and how Chevron should apply. As many of you likely know, Justice Scalia wrote quite powerful, perhaps even angry dissents in cases like Meade and Brand X that in significant respects constrained the range of situations in which agencies would receive Chevron deference. Arlington, rather than following the lead of those cases, represented his one instance to say, no, we should not constrain Chevron's application. We should not have a robust step zero inquiry about what it is that Congress has delegated. We should instead assume that if Congress has delegated authority to the agency, it has delegated authority, and we can let the agency have deference there just as it would in any other instance. Chief Justice Roberts dissented in that case, arguing that Chevron, as it's been come to be understood as a case that rests on a theory of delegation, a theory that may be a legal fiction to be sure, but a theory that reconciles Chevron with the text of the Administrative Procedure Act and notions of the sources of agency power, said that a court should not defer to an agency until the court decides on its own that the agency is entitled to deference. Courts defer to an agency's interpretation of law when and because Congress has conferred on the agency interpretive authority over the question at issue. An agency cannot exercise interpretive authority until it has it. The question whether an agency enjoys that authority must be decided by a court without deference to the agency. In my view, Chief Justice Roberts understood that the delegation of some questions to an agency is not the delegation of all questions to an agency, that Congress can and does delegate power to an agency to decide some questions within a given statutory regime while withholding others, and that if delegation is a precondition of Chevron deference, if our understanding of why Chevron deference exists is not the sort of constitutional theories that were advanced during the Reagan administration or other theories of having some kind of common law roots, but are rooted in a premise of delegation, we really have to take seriously the idea that courts must find that delegation to exist before it provides any deference at all. Now, I think somewhat happily, King versus Burwell, in my view, revived Chief Justice Roberts' dissent in Arlington. It may be the only redeeming feature of King versus Burwell, but we'll take our silver linings where we find them. In King versus Burwell, Chief Justice Roberts said the statute was ambiguous. He may have strained to find it ambiguous. He may have needed to ignore certain portions of the statute and place undue weight on others. But the conclusion of the court was that the question of whether established by the state could mean established by the federal government was one about which the statutory text was ambiguous, but that ambiguity, as the court has said in Meade and other cases, is not enough to trigger Chevron deference. Ambiguity must arise in the context of a delegation of authority to the agency. And in King, Chief Justice Roberts suggested not merely that this wasn't a question for the IRS, but really that this was not a question for any agency, that although the statute was ambiguous, there was no reason to believe that Congress had thought that executive agencies would be able to turn tax credits on and off with the change in individual administrations and their policy preferences. Of course, there was no evidence that Congress thought that tax credits existed in federal exchanges. Not a single member of Congress ever said such a thing, either in public or in private, as far as we know to this day. So it shouldn't be surprising that Congress had not also given any indication that it was delegating a question of such magnitude. So I think in that respect, the King versus Burwell does suggest, by reviving the major questions doctrine in this way, that Roberts' Arlington dissent is at least capable of commanding a majority of the court in some cases. I put it that way, I put it in that tentative way because I don't think we have any reason to believe that all the justices that signed on to Chief Justice Roberts' opinion in King versus Burwell shared his view of the nature of Chevron deference. Indeed, 4 of the 6 justices who joined the Chief Justice's majority opinion in King were on the other side in the city of Arlington. I think, as others have suggested earlier today, they wanted to sign on to an opinion that sided with the administration and that authorized tax credits, and were less concerned with how the Chief Justice got there. Indeed, some of the justices who have joined that opinion have suggested as much, that have suggested publicly that over the last several terms they have thought it better not to focus on doctrinal differences and to split hairs in the context of majority opinions. It was more important to allow the court to issue majority opinions that reached the correct result. So we should be careful about assuming that King versus Burwell indicates a revival of Arlington going forward. I should just note that this has, very briefly, because I know my time is running short, that Arlington has implications for Auer. Aaron said that an assumption of Auer is that, well, the agency really can't aggrandize itself because it can use a regulation or an interpretation of a regulation to narrow the scope of the statute, but not to expand it. Under Arlington, I don't think that's true. Because if the agency gets deference on questions of the scope of its own jurisdiction, an agency can, in fact, effectively redefine the nature of its own power. And if we think about how this actually occurs, so I don't buy the story that the threat of Auer is agencies sitting there saying, ooh, let's issue a vague regulation, and in 10 years from now, we'll spring a trap. I don't think the agencies are exercising strategic behavior in that way. I do, however, think they exercise strategic behavior in the sense that they've issued a regulation, they realize it did not anticipate a particular problem or does not address something that they are now concerned with, but they weren't concerned with at the time the regulation was written, and they recognize that, hey, if we send a letter to somebody, if we issue a guidance, we file an amicus brief, we can get our deference for that. But if we want Chevron deference on the underlying statute, we actually have to go through a lot of work. Under Mead, we have to go through notice and comment rulemaking, or we might have to go through a formal adjudication. That's a real pain, so we'll just issue this other thing and we will treat it as binding. And a good example of this sort of thing, and an example of how Auer and Arlington together allow an agency, if to not at least expand its jurisdiction, but to completely redefine it, can be seen in the current fight over what to do about bathrooms in schools. So I did reach bathrooms. And just in the brief minute, let me briefly explain. The relevant statute at issue in the case of Gigi versus Gloucester County School Board was written in 1972. It prohibited discrimination on the basis of sex. The Office of Civil Rights, the Department of Education, issued regulations in 1975 that clarified lots of things about the statute. For example, that bathrooms are included in the definition of facilities that must be provided equally under the statute, but repeated the phrase on the basis of sex. Fast forward 40 years. The Office of Civil Rights, Department of Education, wants to define on the basis of sex to not merely be a function of biology, not be something that is derived out of some binary conception of the nature of gender or human sexuality, which is clearly what Congress was focused on in 1972, if you read the legislative history, but instead wants to be based on evolving notions of gender identity. I take no opinion about whether or not that is a good or bad policy change. I do have an opinion on the fact, though, that if that's what an agency wants to do some 40 years later, we recognize that normally we would expect and want an agency to, at the very least, go through a notice and comment rulemaking. So it could at least consider the question of, well, if we require schools to allow individuals to have access to whatever lockers or showers that they think conforms to their gender identity, are we forcing schools to create a hostile educational environment in the course of preventing discrimination? For example, a real question and a real conundrum that some school districts have had to deal with. Instead, the agency literally, in the case of Gigi versus Gloucester County School Board, writes a letter to the family involved, and that letter is what the Fourth Circuit relies upon to grant our deference, without even referencing the fact that the Supreme Court has said in a case called Gonzalez versus Oregon that if a regulation merely repeats the language of the statute, there's no basis for giving our deference because what's being interpreted is not the regulation but the statute itself. When you put Arlington and Auer together, not clear Gonzalez versus Oregon was properly decided, and not clear if that's a problem. But if one does think that or a reason to be concerned about Auer is the fact that an agency could, if not expand, but completely redefine the nature of its power and the nature of the rules and rights and obligations it imposes and enforces, well, then that's a combination that should concern us. And I will stop there because I'm pretty sure my time has expired. Thank you.
Contrary to Steve's promise or threat, I will not try to wrap it all up because, in truth, I cannot even follow Chevron's metaphysics. I want to switch the subject and talk about Aaron's paper and some of the points Jonathan just picked up. I think Aaron's paper is terrific. I'm a little more hardcore on these issues than he is. But what it highlights to my mind is a very important subject, which is that administrative law is in desperate need of anti-evasion rules. So the way the argument goes is that our deference might mean, at the end of the day, more adjudication, and that would mean even less notice and less transparency. And if you want to avoid that result, you really have to rethink the doctrine of Chenery too. What he's worried about there and dealing with is what Jonathan just called opportunistic or strategic agency behavior. And I think most of us are vaguely familiar with examples of opportunistic agency behavior, including some largish examples, right? The use of big waivers to create programs for which there's absolutely no statutory authority. The issue of guidances in lieu of legislative rules by the Department of whatever it's called now, ICE, Homeland Security or whatever, the FDA, regulation by settlement, the creation of mortgage programs, which Congress contemplated, never ever legislated, regulation by threat, as in the Clean Power Plan, lots of unorthodox lawmaking and rulemaking, to cite a recent law review article. And the question is, how do you cabin that and get it under control? What do the doctrines of review, what should they actually look like? Now, on one view, maybe there's not a lot of reason to worry here, or a lot of reason for the courts to police opportunistic agency behavior, because agency incentives will, on the whole, do an adequate job. And the argument is that by shifting from one form of decision-making to another, the agency is giving something up. So, for example, on occasion, an agency may just want a rule, in which case, and Aaron talked about this briefly, they don't really want to shift to adjudication. Another example is the choice of guidance documents may be constrained by the fact that the agency, in issuing those documents, is giving up the binding effects of its rule, and if it really wants the binding effect, it will have to issue a legislative rule with the appropriate safeguards. The proposition of the article is that, now that may not be good enough because of the substitution effects, and even if we're empirically uncertain about the cross elasticities, there's good reason to worry. I think there's excellent reason to worry. Here's another view, which is that maybe there's already too many legal constraints. Right? The evasions which we're talking about now into guidance documents and maybe into adjudication or the strategic choice of instruments that get our deference, none of that really mattered before the invention of the modern notice and comment rulemaking apparatus and hard look review, right? And this didn't come up in the 1950s or 60s because you could always do notice and comment rulemaking the way the IRS still does notice and comment rulemaking, which is, page and a half, no response to comment, no legal analysis, just gun it out, shut up. If that's the model of rulemaking, you need not worry about evasion because it's not very costly to undertake that process. So by and large, I think the tacit assumption in Aaron's paper is that this apparatus of notice and comment and transparency and all the rest of it is worth having. I'm inclined to agree with that up to a point. I just want to flag the point because it's not the view of the profession at large. Read Peter Strauss on the rulemaking continuum, you get the opposite presumption. If you reject both of these views that I've just outlined, then you really have to think about anti-evasion doctrines. And I want to sort of just briefly flag how unique administrative law is in that regard. Anti-evasion rules are common in almost any body of law that you can think of. They've been a general principle of statutory and constitutional interpretation dating back to Bonham's case. That's in the 17th century. Right, and the underlying idea is there's not much point of a rule if all the rule does is invite the regulated parties or the targets of the rule to figure out a clever way around it. And so you have to read or interpret the legal rule beyond its literal meaning. Otherwise, the actors will just do indirectly what they have just been prohibited from doing directly. It's quite common in constitutional law. Think of the pretext rule of McCulloch. That's an anti-evasion rule. There are some anti-evasion rules in the Constitution itself, right? If you state cannot tax imports or exports, you cannot evade that rule by taxing the tonnage of the ships. Very common in dormant commerce clause cases. If you cannot tax the imports, you cannot tax the importers either. See Brown versus Maryland, and so on. It's common in some areas that are vaguely related to ad law and partially overlap, such as federal preemption law. So if the statute says you states cannot regulate the rates, routes, and services of airlines, that means you cannot regulate the advertising of those rates, routes, and services either. See TWA versus Morales. They're not common in administrative law at all, and when anti-evasion rules exist, they're really enforced and sometimes not even thought of as anti-evasion rules. So I think the no parroting rule of Gonzalez that Jonathan just mentioned is an obvious anti-evasion rule. It's just a cheap way for the agency to buy itself deference. But the rule is very, very poorly defined and very, very poorly policed. The courts, similarly, there's another example, the ordinary test for the ordinary test for legislative rules is the rule has to have legal effects. There are a bunch of complementary tests designed to shore up that rule, right? Such as, well, if it has a binding effect on the agency, then it's a legislative rule. That's in a way a bizarre test because it comes way too late, because you know only 500 adjudications later whether the agency did in fact treat it as binding. So the rule makes sense only as a deterrent for the next envisioned agency evasion. I think the mousehole canon, or no elephants in mousehole canon, maybe that's an anti-evasion rule, but it's not easily explained. It's also erratically applied and enforced. I think the paralyzed veterans doctrine of law was an anti-evasion rule, except it was the wrong one, and it's now gone. The larger point I want to raise is, why are there so few of these rules, and why is there so little attention to the generic problem? And I think there are three reasons. One is that, administrative law starts with the premise of empowerment, not constraint. Right? And all the big administrative law canons, including Chevron itself, I think, are empowerment canons. Emphatically, Chainery 2. Right? The choice of procedures is the agency's. That's an empowerment canon, and it says there's nothing to circumvent for them, so why worry about it? I realize you can quibble with that. You can sort of formulate the basic premise of administrative law as saying an agency needs an affirmative legal basis for every one of its acts, but I think that's only technically true and not even technically true anymore. See the UARC dissent. The second reason why it's so hard to think about anti-evasion rules in administrative law is that it's hard to say exactly what you don't want to be evaded by the agency. And it turns out to be a whole cluster of things, right? Limits on the agency's statutory authority, OIRA review, judicial review, procedures, and fair notice, which is what Aaron focuses on. So if you want to think systematically about anti-evasion or anti-opportunism rules, you have to have a whole theory of what it is that you don't want them to do, and sort of some paradigmatic theory of how they ought to behave. That's hard to come by. And the third point, and this is a central and valuable part of Aaron's paper, is all the doctrines hang together and they interact, right? That's what his paper illustrates. It's the first thing we try to teach our students. You can't sensibly adjust sort of one doctrine without thinking about the larger universe of doctrines. That's hard for administrative law scholars to do, even on paper. Much, much harder to do for courts in litigation, because the litigants don't do you the favor of bringing up the cases sequentially in the same court so that you can deal with them in a sensible way. So the problem, I think, is very, very hard, but I think it's also necessary to think about it. And the principal reason why I think it's necessary to think about it now is that I think the old models of administrative law, which in one way or another rested on the notion of a partnership between agencies and courts, have collapsed. It's especially true of the sort of old style expertise model, expertise and flexibility, right? I don't think agencies are interested in flexibility so much as in the interorum effect that comes from it. And I think nowadays, I mean, an expert is somebody who, has a PowerPoint show and charges more than $300. I mean, what does that mean? And I think the sort of Sunsteinian model of reasoned decision-making and reasoned deliberation, I think very few people still believe in that. Back then in the 1980s, you could still have an AEI Brookings Joint Center on Regulation. That's an absurdity now. I mean, the very idea is a day of the past. It's all collapsed, I think, under vastly more potent trends towards presidential government. So now you need really law to control this beast. And once you think about law in the form of constraints on agency behavior, you have to take the next step and think about evasion.
Well, thanks very much. Before we turn it over to the audience for questions, I just maybe go down the line and see if people have reactions to the comments of their other panelists. I mean, maybe we could start at the end. And do you have reservations now about overturning Seminole Rock, or what were your thoughts about what everyone else had said?
No, and I don't want to take too much time because I'm anxious to get to the audience's questions. It sort of reminds me, what's the old joke about the folks talking about a restaurant saying, oh, you know, such terrible food, and the other person goes, yeah, and such small portions. I sort of feel like, in terms of what we know now is that agencies clearly ride hour for all that it's worth. We know they prefer that, even with this option for adjudication. Coming from the perspective of the regulated community, at least with an adjudication, the regulated entity is involved in it in some extent in the decision-making process, even adversarially, which I think is perhaps not ideal in this context, but at least there's some involvement there. Whereas under the current regime, that's a null set. So I guess I too find Aaron's paper really, really rich and a lot to think through. But sort of, I'm not convinced that a world where agencies kind of like whack-a-mole run from hour to adjudication is necessarily just as bad as the current regime that we're under. So I would just sort of gently push back on that notion.
Yeah, no, I welcome that. I want to be clear that I think it's an empirical question. And I have hunches and you have hunches, and I think it's probably different at different agencies and at different times and different rules and all sorts of things. The point of my paper isn't to say that it would be worse, but only to say that it might be worse. And until we've actually kind of conceptualized the entire field, we don't know what we're going to get if we got rid of something. And my worry is that we might even think that it's better only because cases are not brought. So if we have a world where they don't have rules, instead they just fall back on their organic statute that says regulate in the public interest, then what's going to happen? Well, agencies sometimes will say, they'll just pick up the phone and they'll say, you better not do that. And if you do, there might be a problem. We might have enforcement, proceeding a year from now. And the regulated party will say, well, I'm not going to do that. There's never going to be a case. So you might say, oh, everything's clean now. Whereas in fact, by pushing things away from rules towards that sort of mechanism, it might be worse. I just don't know. That's the empirical question. But I would say, when I talk about substitution, hey, there are agencies that don't ride hour for all that it's worth. So for instance, the NLRB never promulgates a rule, almost never promulgates a rule. Though they have that power. They do it all by adjudication. Which suggests that even now, even though they could get our deference, Seminole Rock deference, they still think the benefits of adjudication are worth it. Well, I have to think that some agencies who are right on the margin would shift to something closer to that model.
I'll say a little bit. I like. I'll say a little bit about Aaron's paper. I like Aaron's paper. The project of certainly thinking about how changes to one doctrine affect others, I think is very important. It's something there's not enough of. I am skeptical of it for a couple reasons. One, I don't think most agencies prize flexibility. I don't think that is the top of of their list of priorities, either among career officials or political officials. I also don't think they engage in, as I mentioned in my remarks, this type of long-term strategic behavior that at least some criticisms of our are premised upon, but that I think also the substitution theory is based upon. That is to say, and this is especially true of political appointees, they're not making decisions today based on the assumption of what they can do 10 years from now because they might not be there. So I'm not particularly concerned that getting rid of Auer and Seminole Rock means fewer regulations. It might affect the way regulations are written, but I don't think it will affect that many because I don't think the agencies are generally engaged in that sort of long-term strategic behavior, just as I don't think agencies, as an initial matter, adopt vague regulations under the assumption they're going to get Auer and Seminole Rock. I think it more often affects their decision about whether or not to revise regulations once they've identified the fact that the regulation did not anticipate a particular problem or is vague as to a particular point. And then the other thing I would just point out is that there are lots of agencies for which this substitution choice is incredibly constrained by a whole range of factors. Their statutory authority. So EPA, Army Corps of Engineers, for example, couldn't engage in the substitution other than by, especially post cases like Sackett, say in the Clean Water Act context, taking each an individual potential violator to federal court. And they don't want to do that. It's costly. It's time consuming. It is far more time consuming to do on any widespread basis than a regulation. It doesn't have the interim effect. You have agencies like the Fish and Wildlife Service that have vague regulations that send letters to people saying, oh, hey, by the way, if you were to do the following thing on your land, it might possibly destroy habitat. And if so, here are all the terrible things. Here are the maximum criminal penalties we could seek against you. So you might want to think about whether or not you're violating the law before you do what you're thinking about doing. And then they conveniently don't provide much response beyond that when the landowner comes back and asks questions. I mean, so we get that now. So I'm not sure altering Seminole Rock changes that. What it does, though, mean is that if someone challenges the agency in that sort of context, that challenge is going to be occur on a more balanced playing field. They're not going to go into a court with an agency having a trump card, and I do think that affects a lot of things that agencies do, largely in positive ways. Although I think Aaron's point that there could be negative effects as well is certainly one worth thinking about.
Okay, so since we started a little late, we're going to add 5 extra minutes for questions, and I think now we'll open it up to anyone who has questions. I saw that hand first, so why don't you just hand the microphone over?
Whoops, sorry. I would like to hear some thoughts on the sub-regulatory guidance, particularly as directed to essentially a closed universe, which are schools that get federal money, who, if they object if they resist, are faced almost immediately with withdrawal of sometimes millions to billions of dollars of federal funding. I didn't hear anything so far that indicated that courts have taken account of whether it's possible for certain kinds of regulated entities to push back at all. It's one thing to go in and hire Kirkland and Ellis, but these schools could afford Kirkland and Ellis, but they can't afford to lose billions of dollars. So if anyone has anything helpful to say about that, I would be delighted.
It's happened. Grant recipients and banks are probably the 2 areas where this problem's the greatest because temporary disruptions of operations have such enormous consequences, right? So for schools, having your money cut off for a month even is huge, has a huge effect. I mean, at a research university, I know our engineering and medical school knows folks. I mean, anything that could even cause a slight delay, they don't even want to think about. And banks, the same sort of thing with bank examiners. Anything that can cause, they shut down for a day, forget it. And so the result is whatever the agency says goes, and the agencies know it. And I would argue that the existence of our deference is something that gives the agencies more confidence in that exchange. So for example, an official at the U.S. Department of Education, when called before Congress to answer questions about the Title IX guidance given to universities and the due process requirements that universities should or should not provide where there are allegations of sexual assault or harassment or hostile educational environment, told Congress that as far as they were concerned, the guidance was the same as regulation in terms of its binding effect, and had to be kind of educated that actually isn't the case. So that problem certainly exists. I think my own view would be undoing our and Seminole Rock would help. I think also rethinking the way we view injunctions and stays and the like in the administrative context is something that is also long overdue. In the regulatory context, the DC Circuit almost never grants a stay when regulations are challenged, probably out of the legitimate fear that everyone's going to ask for a stay, and then that would slow the wheels of the regulatory process even more than they are already slowed. The flip side of that is that agencies can issue regs. The regs may get challenged in court, but the compliance deadlines are still there and the obligations are still there. And as we saw in Michigan versus EPA, the agency can ultimately lose the case, but still get the effect of the invalid regulation because everyone complies. So there's some issues, there's some doctrines there that at least need to be thought about a little more if we're concerned about the sort of leverage that agencies have in those sorts of contexts.
Hi, that was a great panel. I just had a question about the magnitude of the possible substitution effect. And I have a sense, but I'm not a real strong sense, that there's so many situations in which agencies have to have rules. And I think you hinted that a little bit, Michael. But like, for example, there's no NAAQS without an EPA making a rule. And in the funding situations, the ones I'm familiar with all say that the funding cutoff can only occur under regulations as promulgated by the agency. So I wonder what the sort of magnitude of situations where there absolutely has to be an underlying rule in order for the agency to take even adjudicatory action, so that you couldn't have a strong substitution effect. I don't know if people have a sense of what the magnitude is, as opposed to areas where an agency could actually proceed without having any rules at all, the way the NLRB does.
That's a great question, and I just want, again, I had 8 minutes to try to cover, so I left out a piece of the puzzle, and that is you do have a lot of statutes that say agency can't do anything until after it has promulgated a regulation. And Alice and I were talking beforehand. If you wanted to make an anti-Seminole Rock argument, that seems to me to be the best context for it. For two reasons. One, I'm not as worried about substitution effects there, so leave that aside. But two, even the broad criticism of Seminole Rock, there's a specific criticism of Seminole Rock there, which is Congress has told the agency, we want you to make policy prospectively by rule, and it defeats that specific statute if they just promulgate mush and then do it by adjudication. The whole point of the statute was we don't want this by adjudication, we want this by rulemaking. So in that context, I think the anti-Seminole Rock arguments are the strongest. How exactly it breaks down, ACUS has a source book which has agencies that have rulemaking and adjudicative power. There's a lot of them, but I don't have the exact number. I know that January 2 is a big deal because I see it across a lot of agencies. I haven't gone agency by agency, but it'd be useful to know.
Any other questions? Okay, with that, please join me in thanking our panel.